This is Michael Popok, and it's time for Legal AF After Dark. We're only day 2 of the Manhattan DA's criminal prosecution and criminal trial of Donald Trump. We got 7 jurors in the box. We've got something for everybody. We've got the Manhattan DA moving for sanctions for contempt against Donald Trump and threatening him with jail time, if he violates the gag order. We got the judge admonishing Donald Trump and his lawyers for potential juror intimidation. And we haven't even gotten to opening statements yet. Who better to break it all down than 2 practicing New York lawyers? Michael Popok, that's me, a defense lawyer in New York, and Karen Friedman Agnifilo, the former number 2 in the Manhattan DA's office itself. Take a listen to Legal AF. And this is it. So let's dive in. I laughed before the show. Salty and Ben did a couple of slides that I like. I'm going to call them now, which sort of sums up where we are in the, here's day 1. This is then when Karen and I'll dive into the parts of this that we find interesting. Trump motion to recuse, the judge denied. Yep. Evidence of Trump catch and kill is allowed. The right judge is going to allow that to go as a theme, a theory of the case for the Manhattan DA. Trump's subpoena backfires. We'll talk more about that. Manhattan DA wants Trump in contempt, and if he violates the gag order again, they've asked to have him put in jail. I want to hear Karen's view on that. I think she's got a strong opinion about whether that should happen and will that happen. The judge punted the issue until the 23rd of April, probably allowing Donald Trump to create new evidence and new violations of the gag order that he can then consider on the 23rd of April. I don't think they did any great favors for Trump on that. Trump fell asleep in day 1. The judge ordered Trump to submit his exhibits in 24 hours, and hopefully that's now happened. He fell asleep again, and then half of the first tranche of the veneer of the panel, the potential jurors, said they cannot be fair and impartial, and the judge was like dismissed, in that. And then day 2, let me see the day 2 slide. Look at this. I want to, when we get to it after you comment, I want to roll the tape of a potential new problem for Donald Trump. This tape that we're going to play here, this video, or play the clip, as Ben likes to say, it's going to be played in the courtroom, where he blames, during a press break, he blames his accountant and his lawyer, which is Michael Cohen, for his problem. But the way he did it, I think, also supports the case, makes the case for the Manhattan DA. Trump wanted to play lawyer and go up at the sidebar and talk to the judge, and he waived that right finally. And then the continued jury selection, he fell asleep again. By the way, one of the reportings was, maybe this was from Norm or somebody else, was that he fell asleep while they were talking about the Access Hollywood tape, where he was admitting that he sexually assaults women and gets away with it because he's a celebrity. I guess he finds that boring or funny. Trump tried to intimidate a juror. He gets admonished by the judge, more voir dire. And we put first 6. It's actually, I think now first 7 jurors have been sworn in because they went late yesterday. That's just in 2 days. That, for those that don't practice trial, what we do for a living, that's a lot, even for a criminal case. I want to get your view on it. Karen, pick whatever you want or what is not there to lead off this Manhattan DA first half segment, and then we'll do jury selection issues. And what did you think about the 7? What we know about the 7? What do you think that means as somebody that's presented cases from the prosecution side to a jury like that?
Yeah, so I'll start with a couple things. First of all, I've been reading the live chat while you were talking, and someone named TD wrote "Guilty Jailbirds Sleep," and it reminds me of when I used to go out when I was a prosecutor, and I'd go out on homicide call, and we'd go to the detective squad when they had someone in custody for a homicide, and we'd go to interview, to take a statement and take a statement from the person. And we'd always say there's this sort of lore, this sort of old kind of myth that says, when you get there, if the person is jumping up and down in the cell and yelling and, I'm innocent, that, you got to take that really seriously. But the person's in there sleeping, not too concerned that they've been arrested for murder. You kind of know you got the right guy. Anyway, I just thought that was, it just reminded me of that when they said that. Interestingly, people ask me sometimes, why do you do this? Why do you spend so much time? We both practice law, Popok, we both work full time. And, there's a lot going on in our lives. So what are we doing? What are we doing, spending so much time doing this? And, it was interesting to me when Trump reminds me all the time why we do this, because he will literally say something different outside of court than what happened inside of court. And he did it again here. I overheard a phone call with somebody this morning. I was just listening to somebody who was talking about this case, and the person on the other end of the line said, yeah, and can you believe it that this judge isn't even allowing him to go to his son's graduation? And it's just amazing how that just went viral. Nobody questioned it. Nobody checked for themselves. And it's a small thing, but that's actually not true. The judge said, I'm not going to make that decision right now. Let's see how this goes. It's too far down the road. He punted it. He did not say he cannot go to the graduation. He just didn't want to make that decision right then and there. And so to the extent that you and I and Ben can just as much as possible, just bring facts out into the open. I think it's really important, because Trump just makes these false statements and it goes like wildfire. And because this isn't televised, and because people are busy and they don't have time to go look for themselves, it's just so upsetting that so much misinformation is out there. So that's what I'm trying to do by these daily updates. I'm just trying to, as much as possible, give true facts, what happened, and then my perspective, because I worked in that office for so long. I'm trying to keep it as factual as possible. So getting back to the trial, the fact that he was sleeping, that's been widely reported, is just so reminiscent of what trials are like in real life. As you know, I'm also the legal tech advisor to Law and Order, which is one of my favorite shows. And, what they do is a case from start to finish, from crime to verdict, is always, in a 50-minute episode. But in real life, it takes a really long time to get through a trial, to pick a jury, to go through jury selection, to go through pretrial motions, openings, et cetera. Some of it's boring. Some of it is just tedious. And so I don't fault Trump for, taking a little snooze. It's really just a boring process at this point. It'll get more exciting and intense soon. But right now we are very much in the midst of the part of the trial where there are some pretrial motions that have to be made, and jury selection. And there have been many pretrial motions that have to be made. One of them is called Sandoval. And the Sandoval motion is one where you do it right before trial, right before jury selection in every single case. And what you do is the prosecution gives notice to the court and to the defendant of the prior bad acts. It's all the misconduct and criminal acts of a defendant that is not charged in an indictment that the people intend to use at trial to impeach the credibility of a defendant, should he testify and should he choose to take the stand. So none of this comes out unless he chooses to testify. And this is to put them on notice that these are the uncharged crimes. Because, when somebody testifies, whether it's a defendant or a witness, their credibility is the issue, and always an issue. And so anything going to someone's credibility is fair game. Other than credibility issues, typically you can only limit your direct or cross-examination to facts about the particular case, the crime, things that are relevant to that period of time and to the facts of that case. But with a defendant, you actually have an added protection. If you're just a witness, you can ask them about any prior bad acts, frankly, and it's not an issue. But for a defendant, they have rights. You can't just, it's not a free for all, because what happens is, let's say you have a defendant, like, I'm just giving an example of 10 prior burglaries, and they're charged with burglary. If they testify, it would be unfair if they were to hold themselves out as a productive, law-abiding citizen who never puts their own interests above that of society's. And so because they've committed crime, so you want to be able to cross-examine them, but at the same time, that could be prejudicial, overly prejudicial, because it could tend to show a propensity for committing those crimes. And so as a result, the law has gives a balancing test that a judge applies, and it's when does the probative value outweigh the prejudicial effect of the questioning. And so sometimes what they'll do is, if you have 10 prior burglaries and you're charged with burglary, to mitigate the issue of propensity, they'll say things like, okay, I'm going to let you ask that you have, you have prior felony convictions, but I'm not going to let you talk about all of them. I'm not going to let you talk in detail. And I might let you go into one of them, the facts of one of them. They do this balancing test and they make compromises. So in Trump's particular case, the prior bad acts or acts of misconduct that the prosecution wants to ask Trump, if he testifies, they want to cross-examine him. They brought up things that we've talked about here on Legal AF. They want to talk about the fact that in the Judge Engoron case, the civil fraud case that Letitia James, the Attorney General, brought, they want to go into the fact that he repeatedly and persistently falsified business records, right? And they go into all the details about the things they want to talk about there, right? The fact that they valued a property up to 29 times the appraised value for Seven Springs estate, or for 40 Wall Street, they valued the property at nearly 200 million more than it's worth. And they go through property by property what they want to ask. The fact that he was found to have there's a judgment against him, a finding by the court there, and the underlying facts. Same thing that he testified untruthfully under oath in that proceeding when he claimed that his public comments about a judge's law clerk were instead about a witness. The court held that Trump's testimony rings hollow and untrue. They want to cross-examine him about that. Again, his credibility is an issue, and so that goes to credibility, that a judge found him to have lied. They also, a couple other things from that case, that he intentionally violated the court order by making public attacks on the law clerk, the fact that he violated the court order by failing to remove untrue or disparaging identifying post for the law clerk, and that he committed repeated and persistent fraud. So you have 1, 2, 3, 4, 5, 6 things from that case that they want to go into. That's the perfect example where I predict the court is going to limit it, and they won't let him go into all 6. Or if they do let him go into all 6, they won't let him go into the underlying facts. I just think he's going to say, you can't do all of it. You can do some of it, especially the lying part. I think lying, when you lie like that, I think he's going to be allowed to ask that. He might not allow him to say what you were found, that the judge found you to have lied. That might be a bridge too far for Judge Merchan. Let's see. But those are the types of things that I've seen judges do to do this compromise so that it's not overly prejudicial. Then there's Carroll v. Trump, the 2 defamation cases. They want to the prosecution wants to ask Trump, if he testifies, and talk about the fact that the jury awarded her $83,000 in damages for defamatory statements were made, and that he continued to defame her. And again, that he made these false statements with actual malice, that he sexually abused her, and that he, again, made additional false statements. So there's 4 different things they want to bring out in that case. And then in a civil case, Trump v. Clinton, the court sanctioned Trump and ordered him to pay $937,989 in fees for filing a frivolous bad faith lawsuit. I'm not sure that that's going to be allowed in, because that's more of a lawyer who did that as opposed to Trump. But we'll see. We'll see if they allow that in. And then there's just a few more that they go into. one that I don't think the judge is going to allow in is the People versus the Trump Corporation, the tax fraud case where the Trump organization was convicted of 17 counts of scheme to defraud and criminal tax fraud. I don't think the judge is going to allow that in, and I'll tell you why, Popok, because because Trump wasn't charged. Weisselberg was, and Weisselberg refused to implicate him. I think if I was the judge, and I think what the judge will ultimately say is something like, you could have charged Trump and you didn't. And so I'm not going to allow that in. That could be overly prejudicial. So that's one that I think. The rest, I think there's going to be some version of it that comes in. I don't think that's going to come in. That's my prediction there. Right. So that's where we are right now. As you said, they have 7 jurors. There's been a whole chess match that's been going on that between the lawyers, especially on the prosecution side, that I've noticed them doing. They're really kind of being ginger about what peremptory challenges to use. Each side has 10. Each side has used 6 of them. So they have 4 left to pick 5 more jurors, and then they have to pick 6 alternates. And there it resets. You get 2 challenges per each alternate. That doesn't mean you get 12 challenges, though. You get 2 per alternate. So let's say you have a panel of 20 people. You have a panel of 20 people to pick your 6 alternates from. They won't let you use your 12 because you like juror number 8 over there. You have to go one by one, 1, 2, 1, 2, 1, 2. It's hard to explain it to people who don't sit there.
We're going to do it. Welcome back. That's what we do. And we do it twice a week on a podcast we like to call Legal AF. You probably have a sense of why we call it that. And if you don't know, join us on Wednesdays and Saturdays at 8 p.m. Eastern Time, and you will find out exactly what we're talking about on Legal AF. We curate and collate and incubate the best 5 stories at the intersection of law and politics, and we bring it to you just that way. Wednesdays with Karen Friedman Agnifilo and me, Saturdays with Ben Mysalis and me, and then on audio podcast platforms of your choice. If you know about Legal AF, thanks for being here with us. We really appreciate you. Send that clip off to friends and family. Ask them to join our audience. And if you don't know what I'm talking about, that was Legal AF. And if you enjoyed that clip, join us Wednesdays and Saturdays at 8 p.m. Eastern Time. And then we have a Patreon. Yes, we do. Patreon.com/legalaf. You'll get the building blocks of legal principles, civil, criminal, state, federal, things you've always wondered what they meant. Come to Legal AF's Patreon at patreon.com. So until my next Legal AF, until my next Patreon exclusive video, until my next, hot take. This is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.